Harassment is illegal and not tolerated in any workplace. Harassment can inflict serious damage on an organization's productivity and morale. It causes absenteeism, employee turnover, depression, illness, embarrassment, and humiliation. And managers named in harassment complaints could lose their jobs, their reputations, and even their careers. Managers are the most effective resource an organization has to combat harassment. In addition to avoiding harassing behaviors themselves, managers and supervisors are responsible for preventing harassment among the employees they supervise. Courts have ruled that an organization and its managers can be held liable for harassment, even if they did not know it was occurring. Therefore, it's vitally important that managers and supervisors understand what constitutes harassment in the workplace and how to prevent it. Workplace harassment occurs when people are treated poorly or unfairly because of a perceived difference. Court rulings have established protected groups that are afforded legal protection from workplace harassment. These groups are defined by race, color, and national origin; religion, either because of a person's faith or beliefs, or pressure to join or convert to a faith; disability, either mental or physical; family status, including marital status and pregnancy; gender; age, for employees 40 and over; genetic information; and sexual orientation and gender identity. In addition, local laws and organizational policies prohibit the harassment of many other groups of employees. To put it simply, harassment of any type is unacceptable. There are two types of harassment: hostile environment and quid pro quo. Hostile environment harassment occurs when a pattern of offensive conduct unreasonably interferes with an individual's work performance or creates an intimidating, hostile, or offensive working environment. In most cases, harassment must be continuous and unwanted to rise to the level of illegal harassment. However, while a single, isolated incident does not generally rise to the level of illegal harassment, severely inappropriate behavior, such as the touching of an intimate body part, can be illegal the first time it occurs. Inappropriate conduct can create a hostile work environment even if it's not directly targeted at the person making the harassment complaint. Harassment doesn't just happen between coworkers. Harassment also occurs between employees and individuals not directly employed by their organization. Individuals such as contractors, consultants, delivery persons, vendors, and even customers. Harassment can occur anywhere that employees represent their organizations. This includes work parties, dinner with clients, conferences, trade shows, sales calls, and charity events. The courts use the reasonable person standard when determining if offensive conduct is illegal. In other words, would a reasonable person find the behavior severe enough to create a hostile work environment? The fact is that most offensive behaviors, when they are continuous and unwanted, meet this standard. The safe way to avoid harassment is to avoid these behaviors entirely. The following conduct is unacceptable in any workplace, and when targeted toward a protected group, could lead to illegal harassment: ridicule, mockery, insults, or put-downs; physical assaults or threats, intimidation, or physically blocking a person's movement or ability to work; the use of demeaning or offensive names, or the use of slurs or epithets; gossiping or spreading rumors about coworkers; jokes, banter, or remarks that are demeaning or degrading; menacing looks or gestures intended to threaten, intimidate, or humiliate a coworker; texting pictures, messages, or videos that offend, demean, or harass a coworker; sending offensive or harassing emails, viewing offensive websites, and using social networking sites for harassing or offensive behavior; sexual harassment, which includes any continuous unwanted behavior of a sexual nature, whether physical, visual, or verbal; disparaging comments about a person's job ability, such as, "He is too old to understand technology"; inappropriate remarks or jokes about pregnancy, childbirth, or medical conditions related to pregnancy or childbirth; offensive gender-based comments or behaviors that demean people simply because of their gender, such as, "A woman's place is in the kitchen, not the boardroom"; excluding or isolating employees from work-related activities and assignments because of a non-work-related reason, like race, religion, gender, or sexual orientation. Segregating employees into work groups based on traits like nationality or gender. Making employment decisions such as hiring, termination, or promotions based on stereotypes or prejudices against a protected group. Quid pro quo harassment occurs when a manager or supervisor withholds or awards job benefits on the basis of sexual favors. This includes work assignments, hiring, termination, promotions or demotions, positive or negative performance reviews, or any other job-related benefit. Quid pro quo harassment is a serious offense. Just one instance is usually sufficient for a plaintiff to win a lawsuit. One single mistake could end a manager's career. Managers and the organizations they work for can be held liable even if a threat was not carried out or if a threat was only implied. For instance, a manager who suddenly blocks a subordinate employee's promotion after that employee asks the manager to stop rubbing her shoulders could be guilty of quid pro quo harassment, even though there was no verbal threat of adverse employment action. Enduring harassment as a condition of employment is another form of quid pro quo harassment. For instance, it's illegal for a warehouse manager to tell his employees that they will simply have to ignore culturally offensive comments from their coworkers because they are commonplace in blue-collar jobs. And it would also be unlawful for a restaurant supervisor to tell employees to put up with racial slurs from customers because it's part of the job of being a server. Preventing harassment starts with managers and supervisors setting the example. A manager's actions are the single most important factor in preventing harassment. Always take harassment seriously. Managers should never tell or laugh at inappropriate jokes or comments, even when they think their employees will not be offended. Follow the organization's policies and procedures and ensure that employees follow them as well. When managers don't follow harassment policy, neither will many of their employees. Be cautious when using social media. Comments, pictures, or videos placed on personal social media pages can contribute to a hostile work environment, especially if other employees are part of the manager's social network. Periodically inspect the workplace for objectionable items, artwork, and behaviors. A manager's presence in work areas can greatly reduce inappropriate conduct and catch minor problems before they rise to the level of illegal harassment. Often, a discreet reminder by a manager is all that is needed to stop inappropriate conduct. Remind employees that for less serious conduct, it is helpful but not required to tell coworkers that their behavior is offensive and unwanted. Because managers have a duty to stop harassment before it becomes illegal, employees should be encouraged to report incidents of inappropriate behavior before they become severe or pervasive. Make sure that employees have a copy of the organization's harassment policy and understand the options available to file complaints. Incidents of quid pro quo harassment and severely inappropriate actions, such as the touching of an intimate body part, threats, or intimidation, must be reported immediately. Once harassment has been reported, employers are obligated to investigate it, regardless of how the complaint was submitted. Upon receipt of a harassment complaint, it's critical to listen carefully, remain objective, refrain from offering opinions, carefully document all the facts, and immediately report the complaint to your employer through the proper channels. Contrary to some popular beliefs, most complainants are not looking to get someone in trouble or win a large settlement. They just want the harassment to stop. Give every employee involved in a harassment complaint as much confidentiality as possible. However, warn them that in the process of an investigation, some information will be revealed to others involved with the case. Although some information must be divulged in the process of investigating complaints, confidentiality is guaranteed to the greatest extent possible. It is illegal to retaliate against employees for making or participating in a harassment complaint. Even if the complaint is found to be without merit, the participants are protected if they had a good faith belief that harassment occurred. This means that managers and employers cannot punish or discipline employees with things like less desirable work assignments, less overtime, and or poor performance reviews. Likewise, Non-management employees cannot bully, harass, intimidate, or threaten coworkers for participating in a harassment complaint. Warn all employees involved in the case that retaliation is illegal and will not be tolerated. If the accused employee and the complainant work in the same department, separate them until the investigation is complete. Make sure the complainant is not given an unwanted job transfer or less desirable work assignment to avoid retaliation charges. Investigate all harassment claims promptly and thoroughly. If it's determined that harassment occurred, take immediate steps to stop the behavior and ensure that it doesn't happen again. Apply discipline quickly and fairly, and compensate victims for any losses they incurred as a result of the harassment, such as wages for unpaid time off or restoration of sick leave and vacation time. Harassment has consequences. Both harassment and retaliation can result in disciplinary actions, including written warnings, suspension, demotion, and termination. Harassment charges often affect future career advancement and may even hamper the ability to be hired by another organization. The loss of personal reputation and trust with coworkers, friends, and family can be devastating and life-altering. It's every manager's responsibility to create a safe, comfortable environment for all employees, a workplace free of harassment and fear, and full of respect. Managers who take this duty seriously will not only avoid legal trouble, but will create a healthy, productive work environment with high employee morale as well.